This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Recently, there was some kind of copyright kerfuffle involving Pixar and some kind of painted van that has a unicorn on it or something, and it's known as the Vanicorn. And I thought we should go over the copyright complaint that apparently has been filed for violation of Section 1200 and Section 106. I'm not sure what 1200 is going to be the DMCA. So I'm looking forward to seeing what they're doing there. Let's see what's going on here. Parties, facts. Plaintiff is an artist, photographer, tattooist whose work is regularly posted on Instagram and the website for her tattoo shop, cyclopstattoo.com, and two separate websites for photographs. Over the past 18 years, as a matter of artist interest in particular, the plaintiff has regularly taken pictures of everything that looks like a unicorn, which has been a mythological subject matter of interest since the days of her youth. Plaintiff published a book of her photographs. She called it I See Unicorns. At the risk of belaboring the point, plaintiff has a real thing for unicorns. So this is the plaintiff's attorney saying this. At the risk of belaboring the point, plaintiff has a real thing for unicorns. I love it when we write in plain, clean language.
At least it's concise.
Oh no, absolutely. I wholeheartedly believe that this is the right way to do things. It's just also funny to see that when you're so used to the flourishing language that attorneys like to use. Like, at any and all times relevant here and after. Which is also accurate, but still sounds lawyerly. Plaintiff owned a tremendously cool dark blue or purple 1972 Chevrolet G10 van with red shag carpeting, which I think we can see here. Here is some of the red shag carpeting, the inside of the van. Red velour walls and seating, white shag carpet roof. So, yep, there it is, white shag carpet roof. And that came into her possession in 2014. The plaintiff has joyously, proudly, and frequently posted pictures of the van on her aforementioned Instagram account, a selection of which are attached here too and incorporated herein. So there's some pictures here. There's the side of her van. There's the driver's seat. This must be an undecorated part of the van, or maybe a formerly undecorated part. Yeah, because here now it says it has a unicorn on it. There's even a picture of rainbow next to that. I mean, this is a tremendously cool van. Since the time of the van's possession, it was publicly stated intention of plaintiff to paint a unicorn mural on the side of the van, exclaiming as she did, "Unicorn mural on the way." Plaintiff has an interest in painting a unicorn mural, not only because of her lifelong artistic interest in unicorns, etc. Her ex-husband had refused to allow her to do so. I mean, that's one reason why he's her ex-husband, right? We have to support our spouses, not deny them their dreams. Accordingly, the plaintiff's exercise of adorning her van with a unicorn mural was not only an effort in creating a public work of visual art, but also a redemptive and validating act. Recovering from toxic masculinity and her former marriage. I can definitely understand why she would feel that way. Therefore, subsequent to her possession of the van, the plaintiff designed a unicorn mural with tremendous specificity regarding the colors utilized and the shading thereof, the flowing locks of hair from the unicorn, flashes of lightning. What are they doing here? They're establishing the creativity, the particular expression of her idea, because copyright does not protect ideas, copyright protects the expression of ideas. The plaintiff applied her aforementioned design for the unicorn mural to the side of the van and posted about it on Instagram, brought it forth into the world. It sounds like a birthing meme, like we brought forth this van into the world. A mobile mural or superlative work of automotive art, and she thereafter christened it the Vanicorn. The Vanicorn has been very popular on the streets of San Francisco, enjoyed considerable press attention, etc. So, subsequent to the publication in Exhibit B, which is this article called Fantastic Ride, it has some sort of unicorn even on the dashboard where you would normally put like little trinkets and icons and things. So that's very, very cool. I'm going to use the word cool a lot, I think. She was contacted by Jane Clausen from Pixar, who inquired about renting the Vanicorn for a social event taking place at Pixar's facility. This happened in September of 2018. Sweet Cicely, we just stumbled upon a badass photo of you in your amazing van in San Francisco Mag and shrieked with joy. I'm working on an event over here at Pixar Animation Studio next week and was wondering if you'd be willing to rent us your Vanicorn for a couple of days. I have no idea if you get inquiries like this ever, but it is incredibly perfect for the theme of the event. So I'm going to highlight event here because it doesn't sound like they're asking to use her intellectual property. It sounds like they're asking to borrow her van for a fee. Basically rent a car. Would you let me know if you're open to this? Of course, it would be in good hands. We would make it worth your while, take exquisite care of it, provide alternate transportation for you. So they're going to even give her a car for a couple days and pay you for it. Great. In the subsequent correspondence that followed, Ms. Clausen represented that the event is a one-day music festival activity day for Pixar employees and families. Your van would just be a showpiece and not used in any way other than a visual prop. Are you able to send me additional photos? We've only seen the side. Pixar was clearly impressed by the plaintiff's unicorn mural on the side of plaintiff's Vanicorn. Pixar was only going to be using the Vanicorn for the event, the one-day music festival, etc. However, they agreed that the event would take place September 14th, 2018. The plaintiff would provide the Vanicorn for preparation ahead of time, total to 3.5 days, confidential sum of money, and there's an invoice, Exhibit E, which I guess we don't have. To be clear, Ms. Clausen represented that the Vanicorn would be used for a limited event, which I think they've made that clear. And then there is some sort of license or disclaimer. All rights of every kind in and to all the results and proceeds, including without limitation, photography, filming, and sound recordings arising out of the use of the vehicle in connection with the production, their emphasis added, I'm assuming. Yeah. Shall be solely owned in perpetuity throughout the universe by any means, devices, or methods now known by the producer and its successors and assigns, and neither lessor, the plaintiff, or any of its employees, agents, or affiliates, or any other party now or hereafter having an interest in said vehicle shall have any right of action, including without limitation any right to injunctive relief against producer, successor, etc. Neither producer nor its successors, assigns, licensees shall be obligated to make any actual use of any photography, recordings, depictions, etc. The point cannot be emphasized enough. At every stage of defendant Pixar's interaction, including but not limited to the contract, the production was defined as defendant Pixar's limited use of the Vanicorn and any and all photography, video, and sound recording on the day thereof for the Pixar one-day music festival and activity day. Plaintiff produced the van. A good time was had by all until May 31st, 2019. When plaintiff discovered that defendant Pixar was producing a 3D computer animated motion picture entitled Onward, produced by defendant Corey Ray, distributed by Walt Disney, and featuring the voices of Tom Holland, Chris Pratt, Julia Louis-Dreyfus, and Octavia Spencer. The plaintiff discovered that Onward is about two blue elves who are searching for a magical way to reunite themselves with their dead father. On or about May 31st, plaintiff discovered that they used the services of a third character in the film named Guinevere, which is a tremendously cool Chevrolet G10 van with a red interior, a big mural of the unicorn on its side, and is clearly a direct copy or visual duplication or doppelganger of plaintiff's Vanicorn, down to the very same year, make, and model. Okay, starting to have a little bit of a problem with that. I mean, does she own the year, make, and model? No, I don't think that has anything to do with it. I think it has to do with what she's added, what her expression has added, but I don't know that just using the same year, make, and model of the van is anything. As set forth in a pictorial comparison created by plaintiff and published on our Instagram account, the van named Guinevere in defendant's motion picture is a direct copy or visual duplication or doppelganger down to the very same year, make, model. Here we go. Exterior color scheme, if she's painted it, sure. Interior color scheme, if she made it, sure. And the mural. That's the part that I think I'm most concerned about is, the mural and any... Because remember, copyright protection only protects elements of your expression, not somebody else's expression, not the Ford logo. If your van just happens to have a Chevy logo on it, that's different than if you painted a particular design on top of the Chevy logo and then somebody copied that. And that's Exhibit G. So then here's Exhibit G, and then that is her Vanicorn, and you can see her unicorn, and then here you can see a example of Guinevere. Now I see some things that are the same and I see some things that are different. So let's go over real quick. What have we got? We've got the intrinsic and extrinsic test that we saw the other day in the Star Trek Space Force video. First, we want to look at the idea similarity. And if there's idea similarity, then we go on to a fact finder similarity. So this is called the extrinsic test and the extrinsic test. I got those backwards. The idea similarity is the extrinsic test. The intrinsic test is then like fact finder test, so a jury. So let's take a look. Definitely similar color. Definitely has the same kind of idea. It is a van with a horse painted on it. I definitely think they're both being depicted as a vehicle. It seems to me to quickly pass the extrinsic test. But in copyright infringement, you need not just copyright infringement, but you need access to the original work, which they obviously had access to the original work. They literally rented her van. So we passed the first part of the copyright infringement test there. But you also need substantial similarity. And the extrinsic and intrinsic tests, we're talking about substantial similarity. So we have access. I think we do pass the extrinsic test of like, what are they used for? They're both being used for artistic purposes. They're both being used for creative expression. They're both being used as vans. They're both being used as vans with murals on them. So I think we get straight to, is this actually substantial similarity? Now, if I was an artist, and I'm not much of an artist, so like I consider myself a musician, but I am definitely not a professional musician, and I'm definitely no graphic artist. I do make thumbnails for our videos, and that's about the extent of what I can do. So let me take a look here. We have a van that is definitely the same shape, but the shape of a Chevy G10 van is not owned by our plaintiff here. The year, make, model is not owned by our plaintiff here. Yes, she owns a van of that year, make, and model, but those are not her copyrights. Her copyright is on her creative expression that she adds to the van. What has she added? The red shag interior, the red interior, the white shag roof, interior. The mural, I think, is the most protectable thing on the side of the van, and it is a horse, unicorn horse, rearing up with a flowing mane and a flowing tail in a grayish white horse color. There's mountains in the background. There's sea in the background, or water in the background. There's like a kind of a universe logo, universe effect, with stars and nebula, maybe even a galaxy over here. There is a lightning effect around the rear window of the van, and the lightning effect goes towards the central object of the mural, the unicorn or horse. And then going down here and looking in detail at the Guinevere van, I mean, I see some things that are different, and I see lots of things that are similar. But are they substantially similar? The lightning coming from around the rear window is not coming from around the rear window, but there is lightning. And the rear window has been altered to be a moon shape instead of this triangle or diamond shape. or maybe it looks a little bit like a jewelry stone, like a, was that a princess cut? I think it's a princess cut. The horse is not a unicorn. The horse is a Pegasus, and no one really has a copyright on horses. So you can depict an animal. It's how you choose to depict it. This horse is a kind of Pegasus with wings. This horse is a unicorn. I think that's a horn there, and it has no wings. This horse is flying either through the air unassisted or is jumping. Looks like it's flying because, it's got wings. And there are cloudy things behind it that don't look at all like the nebula or universe model here, although I do see what look like stars. So if I was to guess, I would say that this went through lots and lots and lots of legal analysis at Pixar, and this is what they thought cleared copyright, that they didn't have to pay our plaintiff a license fee, because obviously they didn't pay her license fee, or she would have not filed this lawsuit. But I'm looking at this, and again, I'm not on Disney's side at all. In fact, I'm biased against Disney. So believe it or not, I want the plaintiff to win here, and I just don't see it. I see the case or controversy. I see the reason why she's upset, legally speaking, and why she would want to go after licensing fees. But is this really substantial similarity? I don't know that she owns the scène faire of a horse painted on the side of a car. I think that she owns that particular mural, and maybe even her expression of these lightning bolts coming off of the window. But I don't think that prevents anybody else from making a horse mural on the side of a van and lightning bolts and a universe behind them, or night sky behind them. And this looks like clouds. Maybe it's a different nebula, but it's a different nebula than I see here. I could also see a jury getting there and maybe finding in her favor, but I give it maybe a 10% or 15% chance that she wins, and maybe an 85% chance that she loses. And I'm not trying to be mean. I just think that's where we are.
I was just thinking, so the fact that they admit that they saw her van, I think it would be reasonable to infer that they were inspired by her van, but that doesn't automatically mean that they have to pay a license fee then, as long as they change the final product enough from the thing that inspired them. Is that fair to say?
Yeah. I often get this question and it's usually phrased to me exactly like that. Someone will call up and or hire me to consult, and they'll say something like, how much do I have to change? Is it 30%? Is it 40%? And I'm like, no, it doesn't work that way. We have to go through an entire substantial similarity analysis or fair use analysis or whatever to see if you've made a use that is legal or a use that needs to be licensed. And so if I was the attorney representing here, I would have been hesitant to file this based upon this example alone. Now, if it's true that they also copied the color of the interior of the van and the white shag carpet roof or whatever, yeah, maybe those are also pieces of evidence that you would bring into the case. But I mean, do you really have a copyright on whether you chose red velour interior? I mean, there's limited number of interiors you can have in a car. So if I put a red velour interior in my car and a horse mural on the side, am I somehow? No, I don't think so. I think that is scène faire. I think that is uncopyrightable ideas, and then the copyright is on your specific expression, the total concept and feel of the copyrighted work, is everything together. And I think what they've done here, if I may be so bold, is actually infringe on her trademark. way more than I think that they've infringed on her copyright. I don't know, did they include trademark infringement in this complaint? We're on page 10 here. Let me go up. California Civil Code 987. Let's see what that even is. Advertisement, promotion, or merchandising materials. That one I think is possible. I am not sure what they think is the violation here. Provides copyright management information that is false or distributes copyright management information that is false. I am not sure what in the world they're getting at there, because the DMCA 1201 et sequitur is the digital rights management. So we're talking about DRM. I don't know how that one is going to work in this case. California Artist Protection Act. Okay. No person except an artist who owns and possesses a work of art shall intentionally authorize the intentional commission of any physical defacement, mutilation. So moral rights, they're saying they altered her work, I think is what that's saying. And they want all the relief. Restraining them from distribution, merchandising, promotion, forfeiting profits, promotions, merchandising materials, recalling advertising materials, catalogs, website, books, posters, etc., ordering commercial retailers to refrain from using marketing, make her whole by remunerating her for her work, by paying her for her work, and all other relief, excess of $25,000 in damages, etc. And I get it. I get where it comes from. Where was the California? I guess that was the California Artists' Rights Act. I kind of get it, but at the same time, I don't see it. I personally, it's a professional disagreement, not no defamation intended. I'm not claiming that I know whether or not her claim is good or not, but that's my personal evaluation or professional evaluation of it, just off of what I've seen in the complaint, is that is not enough. I think that's I think it's scummy. I think that my opinion is it lowers my opinion of Pixar and Disney, because I mean, they obviously liked her van. It is obviously a similar copy of her van, but is it so substantially similar that she should have been paid a license fee? I'm not there at 100%. No. I actually am pretty much on the side of Pixar, that although crappy and although I think indecent and immoral, I do not think that it was illegal for them to make their own version of a cool van and make it part of a story. Let's do a fair use analysis real quick, right? Because that's also going to come into this. They might have a defense of, well, yeah, we made a copy, but it's fair use. And they'll assert it as an affirmative defense if this continues. Their creation is obviously not the same purpose and character as her creation. So her creation is to express herself, express her love of unicorns. Their creation is a movie about people trying to get reunited with their family. Yes, they're both commercial works. She's an artist looking for attention. She expressed herself, and people who want that kind of expression will seek her out for her artistic ability, her tattoo parlor, her art, etc. So they're both being used for commercial purposes, but we saw that doesn't necessarily negate any sort of fair use analysis when you're talking about for-profit or rather creative works. So then, how much of it did they use? Well, they used a lot of it, but they also made their own version of it. So I think they lose the third fair use factor if it got there. Does it usurp the market? Well, yes, because she has the right to license her art for use in a movie. So I think the fair use analysis, the only place that Disney could possibly hope to win is in the transformation of purpose. I don't think a fair use analysis saves Disney if this is otherwise substantially similar. Where I think Disney or Pixar might win is that this is not substantially similar. It is crappy, but it is not substantially similar. Maybe they will amend the complaint and add some kind of trademark infringement, because even if this is not a registered trademark, there should still be some kind of state level trademark rights, maybe. And even if not, they can go ahead and register the trademark. And her marketing her business as the as having a Vanicorn, and this being a sort of trademark for her business, this might be confusingly similar. I bet you she can show that this is confusingly similar, and people who saw the movie and know her van would be like, hey, we saw your van in the movie. The confusing similarity test is completely different. It is not a substantial similarity test like copyright infringement. So I don't know. I again, I'm not a trademark attorney. That's why we hire trademark counsel in the case of the Elderwood Hexbox. But in the case of the Vanicorn, I think this is a much better case for trademark infringement than for copyright infringement. But I'm not entirely sure I like either claim really, but I would definitely be exploring the trademark infringement with counsel as well. If they haven't done that yet, they should probably do that. So they had a phone call. Let's see what else they allege here, because there's still a lot to go through here. No defendant ever contacted plaintiff concerning the use of her Vanicorn for visual representation. They did receive a phone call 3 days later, June 3rd. During the course of the telephone call, defendant Corey Ray introduced herself to the plaintiff as the producer of Onward and apologized for the theft of the Vanicorn for its use of the Guinevere character. Okay, that's pretty big. What does that mean? There is a hearsay exception for evidence and testimony. Normally, the plaintiff testifying as to somebody said is going to be hearsay. Well, there is a hearsay exception for when a party opponent makes an admission. So anything that you get the opponent to say to you, you can testify that you were told. Now, your credibility will also be on trial during the trial. So, making things up, saying that the opposing side said stuff, isn't going to be taken as law or established fact. But you would want to include, these are very relevant things, whether or not the plaintiff actually did get a phone call from the defendant and the defendant admitted the theft. Defendant admitted to plaintiff that the defendants intentionally did not inform her, neither in the prelude to the execution of the contract, that they in fact intended to use the Vanicorn as the Guinevere character. The movie had no title. The defendants believed they couldn't have the plaintiff sign a non-disclosure agreement without a title, and so the defendants simply did not reveal their intentions. That sounds a lot like the Crytek case, like, the title of the thing is what matters. Okay, so they did not reveal their intentions, and instead they simply had plaintiff sign Exhibit D. The photographs are explicitly prohibited from being used outside of the one-day event itself. Okay, so that will come into it. If Corey Ray gets on the stand and says, yes, we copied your van, then that will matter. If Corey Ray does not get on the stand and no one admits to the copying, then we're going to go on to a substantial similarity analysis.
So just to clarify, because I had used the word inspired before. So if she can show that Pixar was inspired by her van, is that, and they apologized for taking her design, is that enough? Or do they also have to show that the derivative work is substantially similar?
I don't know what the exact outcome there will be, but I imagine it goes something like this. My client, Your Honor, is not an expert in copyright law, or rather, ladies and gentlemen of the jury, right? My client is not an expert in copyright law, and by saying that she was sorry for copying the van, she was not saying she was sorry for making a copyright infringement of the van, but more so the act of being inspired by the van and using it in the movie without first telling the author of the Vanicorn. However, ladies and gentlemen of the jury, we believe that this is still not a copyright infringement when you apply the actual law to what we've done in this case. We did not make an exact duplicate of the van. We made a duplicate of the idea, and the idea is not protected by copyright. Instead, it is only expression that's protected by copyright, and this expression is not substantially similar to the expression that the plaintiff has produced on the side of her van. Something a little more eloquent, but something along those lines. Onward as a motion picture, defendant's advertisements, production, marketing, sale of merchandise, etc. None of them contained copyright management information for the plaintiff's Vanicorn, and in fact specifically excluded and otherwise omitted. I've not heard this copyright argument before, that the DMCA 1201 or 1201 et sequitur applies to merchandising and movies. And no, it's the digital rights management. In fact, let's just quick go over to that to make sure I'm not missing something. If we go to 17 USC 1201, this is for the circumvention of copyright protection systems. That's what we usually mean by copyright management. 1202, integrity of copyright management information. False copyright management information is information conveyed in connection with copies or phonorecords of a work, or performances or displays of a work, including digital form, identifying information about a user of a work or of a copy. Okay, I guess that's what it says. I have never seen anyone assert a claim for copyright management information. So if they did not include the correct copyright information, I guess like credit for the work, then that's considered a violation of 1202. So I learned something today. I was not aware that there was an actual claim for misrepresenting the copyright owner. Let's see, the title or other information of a work, the name of the author. Okay, so that's interesting. Let's see what the remedy is. Is there a remedy? I don't see the remedy listed here. Maybe they just consider it. Here we go. Any person injured by a violation of 1202 may bring a civil action, so it is a civil remedy, and the court may grant injunctions, impound products, devices, award damages, allow recovery of costs. We're learning something here, everyone. They can award statutory damages of not more than $2,500 per act of circumvention under 1201. Okay, that's not it. 1202, not less than 2,500 and more, or more than 25,000. So that's a new one that I have not seen. So misrepresenting the copyright information, misattributing copyright information is a violation that can come with actual damage awards or statutory damage awards. That's we learned something new today, everyone. Even I've learned something new.
I wonder if this would apply when something is, say in the public domain, and then you directly copy it and then say, I'm the copyright owner, even though you haven't added any extra creativity, and then try to sell, like, for example, like claim it on YouTube from somebody else, like somebody else's YouTube or something like that. You are misrepresenting that you are the owner of that material. Like, that's what pops into my head.
If it's in the public domain, yeah, I guess you could still have a violation of this. That's a good one. That's a real good question. Because if Leonard French produces a work, Leonard French dies, 70 years later, it's in the public domain. Or let's clean it up a little bit. Leonard French is still alive. Leonard French has assigned a work of his to the public domain. And that's that you can do that, and then you'll still be alive while your work is in the public domain. That's really the only way I can think of that would happen. So let's say that Leonard French has assigned a work to the public domain, and then someone comes along and uses that work, but says they're the owner. I guess this would work, but it just seems like this is in perpetuity. So in other words, Rhapsody in Blue, George Gershwin's Rhapsody in Blue has recently come off of copyright, and I have a printed copy here that I made for myself of the original, which, by the way, takes 2 pianos to play. I didn't know that part. I only have 1 piano and 2 hands, so screw me, I guess. But if I then went and made my own performance of George Gershwin's Rhapsody in Blue, and I said, no, this is Leonard French's Rhapsody in Blue, would the rights holders who no longer own the copyright to the Gershwin Rhapsody in Blue, would they be able to come and say false designation of copyright management information? Maybe. I think I have some research to do because I have not seen this type of claim before. Very, very interesting. Let's just continue and see if they have anything more solid. So the Vanicorn was willfully, intentionally, etc., stolen, unlawfully used, reproduced, used in their infringing motion picture, plaintiff has not given consent, no consent, defendant has not been compensated. So it seems like the only real admission is the phone call from Corey Ray, who may have wanted to talk to the attorneys first before calling the plaintiff. That aside, let's see what I is. Meanwhile, she is... Wait a minute, this looks like they. This looks like the Pegasus. My glorious quest to find all the best exclusive merch at the 2019 D23 Expo by who? Okay, so this is the merchandising efforts, because this is a duplicate. Someone has created a van that looks like the Onward van created by Jay Ward. So they're saying this is also some sort of false copyright information. So they have definitely gone on to create a real life van. And there's a sort of better example. You've got the moon as a sea over here. The lightning is not coming from the moon. The Pegasus is not it's a unicorn Pegasus. I'll take that off because that looks ugly as heck, but it is a unicorn. But it's a unicorn with wings as opposed to a unicorn without wings. It is sort of nebulous in the background as opposed to cloudy, and those are stars, so that does clear that up a little bit. So yeah, she's got nebulas, they've got nebulas, they've got a night sky, they in both of them. So yeah, oh man, this is really right on the line. Maybe I'm gonna change my prediction because there's an admission. I would predict that this becomes a much harder case for Disney to win, for Pixar to win, if that admission is true. If they get Corey Ray under oath and Corey Ray confirms, yeah, I said this was a copy, I don't know, that sounds almost to me like they've lost the case. But if nobody admitted anything, I think we're back to a jury having to evaluate substantial similarity, and I am not sure how a jury would find on this one. They are obviously very similar. I don't know if they're so substantially similar that one is a copyright infringement of the other, but I could really see a jury going either way on that one. That's not terribly helpful, but maybe you can let us know your thoughts in the comments of the video below. Okay, so unicorn Pegasus are alicorns. Is Pegasus Greek or Roman? Is it Pegasa or Pegasi? Pegasuses. All right, so that's our show. Let us know what you think in the comments below, and thank you for your financial support. Lawful Masses is a community-supported legal education channel and would not exist without your monthly financial support on patreon.com/ljfrench and sponsors.com/law. In the month of February, we have $50 plus supporters who contribute and get their name read at the end of our videos. For the month of February, our $50 plus supporters are Aspernari, Video Demonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Steven, Cute Grills in Your Area, Ottah, Kysal, and Longreach Jones. Thank you very much for all of your support. The $5 plus supporters will be scrolling on the screen in front of me, and everyone's in the description of the videos below. I am Leonard French, your favorite copyright attorney. I love you all. I will see you in the next one. Have a good one. Bye.